Thanks, Kelly. Good morning, everyone. For those of you who don't know me, I'm Julia Simon Michelle. I'm the supervising attorney of the Unemployment Compensation Unit at Philadelphia Legal Assistance. Philadelphia Legal Assistance will be handling the sessions for this morning. I'll be handling the first hour, and then two attorneys from my unit, Rachel Miller and Aaron Summer, will be handling the training on hearing practice. And then I'll join you guys again in the third hour to talk about some overpayment issues we're seeing and give some updates about unemployment benefit modernization that is coming our way. We're also going to try to fit in a very brief break between the second and third sessions so that people can go take care of business for a couple of minutes, since we know how painful it can often be to just sit in front of your screen on a Zoom for hours straight at a time. I'm also going to ask folks to try to wait to the end of the presentation to ask questions because there's a high likelihood that I will get to the issue that you might have a question about, but I am going to try to leave considerable time for questions at the end of the session. So with that, let me go ahead and share the presentation. Okay, so a lot of what we're going to be talking about today is already familiar to many of you, but I'm going to be trying to update folks about kind of what's happening along the way, and especially some of the changes that have happened since the CARES Act extension was passed in this past December. So as you all know, for current Pennsylvania unemployment compensation benefits, claimants can qualify to up to 26 weeks of benefits. Right now, there's an additional 24 weeks from pandemic emergency unemployment compensation, the federal extension, plus up to an additional 13 weeks of extended benefits. I'll talk more in detail about both of those in a few minutes. Benefits range from $68 per week to $583 per week. You'll notice $583 is an increase. That's because when we changed calendar years, we did see a slight rise in the top earning benefit rate for Pennsylvania. Regular unemployment benefits are paid every other week. They can still be paid by direct deposit or debit card. It's important that folks file for regular unemployment compensation on the bi-weekly schedule. Every once in a while, the system will let you file weekly, but it can cause other problems in the system because so much of its programming is based on bi-weekly filing. So even if somebody is able to file weekly, we strongly recommend that they stay on the bi-weekly filing schedule. And last but not least, as we all know, for regular unemployment compensation, pretty much all communication and notices and decisions come by mail. So it's really important that all claimants have a correct updated address in their system, in the unemployment system, so that they get their mail. Now, there's still significant mail problems happening across the state, especially here in Philadelphia. We have recommended that a lot of our clients sign up for informed delivery from USPS so they can at least get notified when mail is coming their way. That can often be very helpful for some of these cases, but it is still a problem that lots of claimants are not receiving their mail related to unemployment. So I wanted to go back to the very beginning of the crisis when we first talked about COVID-19 and eligibility for unemployment compensation way before any of the federal programs showed up. And this is because there's been a lot of confusion over the last year by workers about what program they're supposed to be in. A lot of workers have gone straight to the Pandemic Unemployment Assistance Program because they lost their job due to COVID-19. But for W-2 workers, almost any reason you lost a job due to COVID-19 should qualify you for regular state unemployment compensation. And in fact, you are required to seek that first. So there's a lot of folks, and I'll talk about this a little bit later in the program, who went to PUA, who should have been in UC from the get-go and are now being moved between programs because of this issue, right? So if somebody had to quit due to unsafe conditions, if they were laid off due to COVID-19, if they were fired because they contested unsafe practices, or they were fired because they were absent due to COVID-19 or the need to quarantine, if their hours were reduced, if they don't have access to childcare and need to take a leave of absence or quit their job. All of those fall within the coverage of our state law because our state law is actually pretty generous compared to many other states in the country. And a lot of these reasons on the voluntary quit side should constitute good cause. So it's really important when you're working with claimants to clarify what their work history is. And generally, if they are a W-2 worker, they should almost always be applying for regular UC unless they've recently been found not financially eligible for UC, and then they could go straight to the PUA program. But it's important to remember that UC covers the majority of situations that we are seeing right now due to COVID-19. So the federal extension. Pandemic Emergency Unemployment Compensation, PEUC, was passed as part of the CARES Act last March. It was originally for 13 weeks, and then in December, they extended it to 24 weeks. The way that works is they added 11 new weeks in 2021, meaning that those weeks cannot apply retroactively to weeks in 2020 where people were not getting paid. They can only be collected in 2021. I will say that there is an exception to that, which is that the unemployment compensation mainframe computer somehow did pay, we're unsure how many claimants, but a significant number of claimants, the system paid them for weeks in 2020 with the PEUC extension, which was incorrect and problematic because then they did not get the extra $300, which we'll talk about. Federal programs for the department is aware of that and are working on that. They should just be issuing, in essence, non-fraud overpayments for those weeks and refunding the accounts so that they can collect those weeks in 2021. But for most people, the 11 weeks only go to 2021 or only used in 2021. Right now, the program is available until April 10th, 2021, meaning that if you have enough weeks to get through April 10th, you can continue to collect until then. But the vast majority of people who were relying solely on the new 11 weeks are going to exhaust their benefits on March 13th. Now, we are waiting impatiently for what is happening in Washington, D.C. right now. The reconciliation bill would extend PEUC right now through the end of August. And so it is set in that bill to be retroactive to March 14th. So there should not be a lapse between weeks, but I expect there to be a lapse in practice given the timing of when that bill is probably going to be passed and implemented. Right now, what we are telling all of our clients, people calling in, is that they should keep their eye on the Department of Labor and Industries website, uc.pa.gov, on the Department of Labor and Industries Facebook page, and on Philadelphia Legal Assistance's Facebook page. And as soon as anyone has updates about how the extension is going to work, when they're going to get it, how that relates to filing new claims and things like that, that information will be posted. We don't have that right now. We're not sure how everything's going to work, but people should check those sources constantly for updates and information. For PEUC, it is automatically added to claims. So what people don't need to do is pretty much ever use that one-page PEUC application that they see online. We have a lot of people still trying to use that to get PEUC. They don't need to do that. And in fact, it could just create a double claim in the system. It will be automatically built on. And if you're someone who has gone online and checked somebody's unemployment benefit payment history, you'll see that they just kind of add the money in to the PEUC claim that was already existing. And so that, again, all happens automatically when you exhaust your regular UC or you exhaust your EB, which we'll talk about in a second. The extension's automatically added. And we'll talk about it in a second, if claim years end for people on PEUC and they have earned wages, they should definitely file a new application for benefits. Again, we are waiting to hear what the department wants people to do if they haven't worked since they filed their initial application and are coming up on the end of their claim year. They have said that they are going to release press on this, but we have not heard anything. For example, New Jersey told folks that that they should not file a new claim year if they haven't worked at all, and that they're going to do a systemic check on the back end to make sure they're not eligible for a new claim, and if not, continue them on the extension. We have not heard anything like that from Pennsylvania yet, but they tell us it's coming. One other thing to know about PEUC is that we did have many claimants in 2020 who exhausted PEUC and extended benefits and were then able to get on pandemic unemployment assistance because they had a COVID-19 separation. And so they were collecting PUA up until the end of that program on December 26th originally. And then after the extension, they continued on that program, even though they really should have been back on PEUC at that point. So the law passed in December created a hold harmless provision. So if you have claimants who were collecting PUA during 2021 when they should have been back on PEUC, for at least the first 4 weeks of that, it's not considered an overpayment. It just goes towards their PUA total eligibility. And they should then be moved back to PEUC to start collecting on that. If it goes past 4 weeks, which clearly we are now, then I believe it will be a non-fraud overpayment for any weeks on PUA when they should have been on PEUC. So they tried to give some flexibility to states, knowing it was going to take a while to move people back. But if you have exhaustees still on PUA, it's really important to make sure that you get them moved over and tell them to stop filing in PUA now and go over and file back on PEUC. As a reminder, when I say file on PEUC, that is just filing your regular bi-weekly claims online. There's not a specific PEUC bi-weekly filing. It's just filing regularly on the UC website or on the PAT telephone number. One other thing that got added to PEUC in December is there was a lot of concern about the fact that workers would qualify for a new claim year after their previous claim year ended, and the new claim year was going to have a much lower rate than what they were getting before and what they were able to get through the extension. So they put in a fix that existed back with EUC during the recession that says if a claimant in 2021 files a new claim and their new weekly benefit rate is at least $25 less than the weekly benefit rate they had been collecting on PEUC, then what the Department of Labor and Industry will do is they will build the new claim, but they'll place it on hold and allow the claimant to continue to collect PEUC for as long as it exists at the higher rate. Okay, so this is to protect people who would otherwise see a significant dip in benefits because of the new claim. It's really important that if you believe somebody is eligible for a new claim, that you have them file. Because the whole thing, as we all know, because of financial eligibility, it's possible that someone might be eligible for a new claim now, but if they wait until they exhaust PEUC in, let's say, August, they might not be eligible for a new claim then because of when their wages were earned. So it's really important to have them go ahead and file if they've earned since the first application to preserve their right to that new claim, right? But again, they won't be harmed if their benefit rate is at least $25 less. So maybe it's $20 less, and that's really frustrating, but for the vast majority of people, this is going to make sure that they continue access to benefits at a higher rate. So we also still currently have the state extension, the extended benefits program in place that provides half of the weeks that somebody qualified for in their initial UC claims. If you qualified for 26 weeks, you get 13 weeks. If you qualified for 18, you get 9 weeks. Similarly, that is automatically added to claims. People do not have to apply. It remains in place as long as PA is in high unemployment. And so what that means is there is a look back in comparison to the previous year to determine whether we are comparatively higher in our unemployment rate than we were in the last year. That's been great up until the fact that we're about to hit in 2 weeks the highest point of unemployment, I think, ever in this state in last year, March 2020. So there is some concern that EB is going to trigger off at some point in the next 2 months. There's kind of a delay in when that happens. There will be a notice period before EB triggers off, but it may end sometime in the next 2 to 3 months because the look back period had substantially higher unemployment, a substantially higher unemployment rate than what we have right now, even though the one we have right now is crazy. The thing that I think most people who are working actively with claimants realize right now is that one thing that did happen in the December bill is that it put in a requirement that anyone who had already been on the extended benefits program prior to December 26, 2020, had to continue on that program before they could move on to the 11-week extension of PEUC. And so we have some people now who are just finishing up that EB and moving back onto PEUC. There were a lot of people who were incorrectly put on EB who had exhausted PEUC on December 26th. The state, I believe, has now moved most of those people to the correct program, but there was a lot of confusion about this. If they were correctly on EB prior to December 26th, they stay on it until they exhaust it. If they were incorrectly placed onto EB on December 27th after PEUC ended, then they need to be moved back to PEUC, and the government should be doing that. So one thing we've talked about before, but just a reminder, filing for EB is different than filing for regular UC or PEUC. They cannot file using the automated PAT telephone system. So they cannot call into PAT to file. I believe if they call into PAT, it will tell them that their claim is inactive. Similarly, when they log in to file their biweekly claim online, it will tell them that their claim is inactive. But there is a little note that says if you have an EB claim, use the File an EB Claim button at the bottom of the screen to file. So you'll see what that button looks like. That should be there for everyone who has an EB claim and is actively collecting on an EB claim. If that button is not there and you believe someone should be on EB, that's something to contact the department about because there might be some issue with that person's claim where they haven't built their access to EB in the way that they should. And just a quick reminder, the general order right now is regular UC, PEUC, then EB, with the exception of that, that one area we talked about before. The whole opportunity to get PUA for exhaustees may not really come into play now, given that it looks like PUA and PUC are both going to be extended for the same amount of time. So I don't really think we're going to have people exhausting their benefits on regular unemployment and the extensions and moving to PUA anymore. But if that does change, we'll let you know. So federal pandemic unemployment compensation, PUC, is back. It's back at half of what it was. It's an extra $300 a week for claimants in any program in which they're receiving a type of unemployment benefit. A reminder that it works the same way as the $600 did over the summer. As long as you were eligible for 1 week of unemployment benefits, you qualify for the extra $300. So it's not the same as LWA, which was in place in August, where folks had to be eligible for a benefit rate of at least $100 a week. Not that. As long as you qualify, no matter what your rate is, for at least $1 in partials a week, you will get the extra $300. PUC was put in place as a time-limited program again. It was for the week starting December 27th until the week ending March 14th. So it was for a specific 11-week period. The way it works on PUA is that it's paid at the same time as PUA benefits. So folks file weekly for PUA and they get paid both the extra $300 and their PUA benefit. For unemployment compensation, folks get the PUC a week after, right? So they would file on a Sunday, get 2 payments of their regular unemployment, usually by Wednesday, and then usually the next Tuesday, they get 2 payments of the extra $300. Now, there is also a proposed extension to PUC in the reconciliation bill that's moving through the Senate right now. It's currently at an extra $400 per week, so it would go up $100, and I believe it is set to last for the duration of the extensions for the program, so that would also be through August of 2021. So again, we're waiting to see how that all shakes out, but the idea is that PUC, this kind of the supplemental benefit, will continue. Again, nobody has to apply for anything to get PUC. It is automatic. Please, please, please double check with your clients that they haven't filed something else thinking they're getting PUC. we have an incredible number of people who filed for pandemic unemployment assistance, PUA, thinking that was how they could get the extra $600 or the extra $300, and were collecting in both systems by accident because they didn't understand. And the government's going to come after them hard, and we're going to talk later today about how to defend in that situation. But it's really important to be very clear with people that this is automatic. They should not submit any other application for any other program online to get it. Just stay in their program that they're in. It'll come automatically. So speaking of pandemic unemployment assistance, so pandemic unemployment assistance is the federally funded program that provides benefits to workers who lost work due to COVID-19. That's the important part here, but do not qualify for regular UC. So again, you must not qualify for regular UC to collect PUA. PUA originally was set at 39 weeks. And in December, they extended it for another 11 weeks, providing a total of 50 weeks of benefits. But similarly to PEUC, the 11 new weeks were only possible for weeks in 2021. So they were not retroactive. They're still fighting for a lot of regular PUA benefits and PUC benefits for weeks in 2020. People have not lost their right to those benefits, but I know that a lot of people are still trying to get them, including backdating, in which the department is just completely, has completely delayed any grant of backdating in the PUA program that has been really frustrating to a lot of claimants. There's still a lot of fraud in this program, unfortunately. And again, when I'm talking about fraud, I'm talking about criminal conspiracy fraud. I'm talking about massive identity theft being used to file claims on behalf of other people. So we are still finding people who are receiving 1099s for benefits they didn't receive, who are trying to file a PUA claim but can't do that because there's already a claim in the system. So when that happens, it's important for them to report the fraud to the department so that they can mark that claim and not hold that person responsible for the benefits received. If folks have received a 1099 for benefits that they never applied for and they didn't receive, what both the department and the IRS is telling folks is they do not need to report that 1099-G with their taxes. They can pretend that it doesn't exist, make sure they've reported it to the department. At some point, the department will issue a revised 1099-G that zeroes out the income. Now that's really scary for people because it feels like you're lying to the IRS and it feels like you're going to get audited, but that is what both the IRS and the department has told folks to do. If anyone ends up having any issues with that, they should go to their local low-income tax clinic for assistance if they have any issues. But that is what the government is telling folks to do if there was a fraudulent claim in their name. We also, of course, have a lot of people who are receiving 1099-Gs who did not receive the amount of money listed on that 1099. This is much more likely to happen in the PUA system than it is to happen in the UC system. There are two situations we often see, and this is for both PUA and UC, which is that people didn't realize that the extra $600 and the extra $300 were taxable. And so that money is also showing up on the 1099-Gs. And once they consider that, then oftentimes they're like, oh, I did receive that money. But then for a lot of PUA claimants, they are not certain that they received the amount of money on some of these forms. And that's because of all the payment problems we had with the PUA program earlier in the year, where they switched to checks and then they switched to debit cards. And there's a lot of people who are still missing payments from earlier in the year, often from checks that were mailed out. And so if somebody does not believe that their 1099-G is accurate, the first and foremost thing is, rather than trying to change what you're reporting to the IRS, is to go to the department or Treasury and try to figure out what happened to the money that they think they paid your client. Where did it go? Most often it could be, like I said, a check that was never received. So if you look on somebody's PUA portal and you look at their payment history, if a whole bunch of payments have the same transaction number, that means they were probably paid by check. So that's one way to kind of go back and troubleshoot with your client to see if they might have received or may have been issued a check that they never received. So first and foremost, we want to make sure we get people the money that they are actually owed and that the government is holding them accountable for. Finally, with pandemic unemployment assistance, there are new backdating restrictions that were passed in December. So if somebody files a new claim for PUA after December 26, 2020, instead of being able to backdate to the loss of work at the beginning of the pandemic, at the earliest was February 2nd, 2020, they can only be backdated to December 1st, 2020. In essence, the federal government or Congress was trying to prevent people from getting benefits who they thought sat on their hands and hadn't filed. There is an exception to that has been read into the law by the Federal Department of Labor, which is if policy changes and somebody becomes eligible for benefits that were told they would not be eligible for benefits before, they can get backdating to the beginning of their loss of employment. And similarly, if they had filed a claim for unemployment compensation and recently learned they've been disqualified, their PUA and qualify for PUA, their PUA claim should backdate to the date of their UC application. So I'm curious to see how this works out. We have not had too many situations like this yet. So I don't know how well the department is applying this, but we will be keeping our eye out, and please let me know if you have clients who are struggling with these exceptions to the backdating rule. So PUA, as I think everyone can tell who is on the employment listserv, seems to be our most problematic program by far. It has been incredibly frustrating for people since the beginning of the program in April of 2020. And of course, when the program was brought back to life at the beginning of 2021, there were a ton of glitches in the rollout. Now, to the department's credit, and I won't be saying that phrase a lot during this presentation, they did fix the glitches rather quickly this time and kept people updated. Their communication greatly improved about what those glitches were and when they were being fixed. There are a few things to still be aware of. The system is incorrectly recalculating some weekly benefit rates based on 2020 income. That should not be happening. If a claim was originally filed in 2020, even if it's reopened in 2021, the weekly benefit rate remains the same. It's based on 2019 income. The only time 2020 income is going to be considered is if a brand new claim is filed in 2021. So if that's happening, if people get a notice that changes their weekly benefit rate based on 2020 income, they should appeal that new monetary determination to make sure that it is fixed. While work authorization has always been required for the PUA program, it seems like somehow they did not actually mark who had work authorization during the first 9 months of the program. And so now non-citizens are being asked to provide documentation of work authorization, even if it's been uploaded on the system for months already. They're being asked to upload it and notify the department that they have uploaded it before benefits will be released in the year 2021. Adjudication of these benefits, as we've all discussed, is a disaster. We don't know what guidance PUA agents are being given about how to do adjudications because it seems often like a crapshoot, and they are asking for ridiculous amounts of documentation that does not seem supported by the CARES Act or federal guidance, especially when they are asking for identity documentation that people should not need to provide if they've already gone through ID.me. And it feels often like they are ignoring self-certification provisions. We are raising these issues with the department. I believe the Federal Department of Labor is also taking a look at this because it's been a problem across the country in terms of states kind of tightening tightening access to the federal program. The other thing is that most people, like claimants, could be waiting months and months and months for any communication from PUA, and then all of a sudden a message shows up in their portal that only gives them 4 days to respond, which we think is pretty unfair. But it means that they need to be constantly checking their portal and that they need to set their communication mode in their portal to be internal message with email notification, so that if they get a message in the system, they also get an email to the email address they use to sign up for PUA. Otherwise, depending on what they chose when they first opened their application, they may not get any form of notice outside of what they see when they log in, which is problematic because some people aren't logging in every week now, especially if they had finished the program. And they could still be getting determinations and overpayments and things like that. So it's important that people set their communication type to internal message with email notification. The other issue is, of course, any notices that are disqualifying individuals have minimal information. It's a due process violation the way these notices are currently written. We have raised this issue because we literally have no idea why someone was disqualified based on the language that is being used. And we're waiting to see kind of how that gets handled by some referees in terms of kind of what they think their jurisdiction is on the appeal, given the lack of information in the underlying notices. So we did talk a little bit about before that despite our frustration with the department about all the documentation they are requiring, there is a new documentation requirement for Pua that requires claimants to provide, in essence, substantiating documentation that shows that they had employment or self-employment or the planned commencement of that. And they have to provide that within 90 days of January 31st. We haven't heard anything from DLI about this, no guidance, no nothing. And that could be extended with good cause, and my guess is it may get extended by DOL. The key, though, is despite how the Department of Labor and Industry has been handling eligibility issues throughout PUA, the proof of that work only has to be at some point between the start of the applicable tax year, which is 2019 for most people, and the date of filing, right? For a lot of people, March 2020, right? So just at some point during that time period, they have to have documentation that shows they were working or about to start work. And so that is actually a pretty lenient timeline. The documentation can be what they already have uploaded online for their weekly benefit rate reconsideration. However, it can't just be based solely on the fact that there are wage records from W-2 employment in the system. We are hoping that may get changed by DOL, but that is what is in the current UIPL. So there's not really any real restrictions on the documentation that can be used. It's pretty broad, and I expect that we're going to see it broadened even more by the Federal Department of Labor. But again, we still have no instructions shared by our department. Again, tax documents are the easiest, but also, any sort of business records, any sort of agreements, contracts, letters, pay stubs, anything like that should be enough to meet this requirement. We are starting to see more and more determinations issued in the PUA system. Aaron and Rachel are going to talk about the actual kind of appeal process and appeal hearings for those, but I did want to give the update that claimants can file appeals of PUA determinations in their portal. It's important that they appeal each determination because they're not automatically batched on the back end like what happens in the UC system. They can also still file appeals by emailing ucappeals@pa.gov, but some of those appeals then don't show up in the system, and so we strongly recommend them doing the appeals through the portal. However, if somebody is past the appeal deadline, the portal won't let them file an appeal, which I have raised as a due process issue, and they are aware of and should be changing. So if somebody can't file online in the portal, they should go ahead and just send the email. PUA appeals only recently started having hearings. There was a real delay because the PUA system built by Geographic Solutions Incorporated could not communicate with the referee offices. It was a whole thing. And so I believe January is the earliest we've had a PUA hearing. There are 7 referees across the state who are specifically tasked with hearing PUA appeals. I think it's possible that we may have other referees hear them as well, but those 7 are specific to PUA. And fair warning, some PUA hearings may occur on Saturdays. They're trying to catch up, and so they have extended the time to have hearings to Saturdays as well. if you are looking at a claimant's portal, or they're looking at their portal, if they go to unemployment services on the menu and then appeals, they'll be able to see the progress of their appeal, whether it has been filed, if it's been processed, if a hearing has been scheduled. All that information will be on the appeals tab. So the one, oh, go ahead.
I'm sorry. This is Kelly. If I could just interrupt quickly, I'm going to launch the first of the CLE poll boxes. This is for participation for this hour's session. So attorneys on the call, if you could please respond. I will leave it up for about 2 minutes, and Julia, please feel free to continue.
Sure, and great timing, because I'm actually going to switch out of this presentation for a second, because one of the good things that has happened with PUA is that the new administration in DC has issued a change as of last week that has expanded PUA eligibility. So, okay. Can somebody unmute themselves and let me know that they can see what I'm showing as a self-certification declaration right now? Anyone?
Sorry, you can see it. Yep.
Okay, great. So this is the example self-certification declaration that DOL just put out. So, you all are familiar with many of these already. Oops, sorry. These are the ones that have existed since the beginning, about COVID-19 eligibility for PUA. However, recent UIPL, they expanded it. So the big expansions are, and there's an entire, I can send out the UIPL to anyone who's interested in looking at it. But the two big ones are that if you were denied unemployment for a refusal of work, then, and it's because of the workplace not being safe, you should qualify for PUA based on that. So that you may have gotten disqualified from regular UC, or you were not eligible for regular UC for some reason, but you refused to go back to work. And now that you refuse to go back to work because it's not safe, you should qualify for PUA. Another one is that individuals who worked in education can now qualify for PUA if the volatility of their work schedule is directly caused by COVID-19. This still involves some reasonable assurance issues, but it helps a lot of the people we know who work for educational agencies who had other self-employment income that they weren't able to use to qualify for regular UC, but might be able to use to qualify for PUA. And then I think most importantly for us is that, one of the issues with PUA as it was originally written was that you only qualify if your business is closed, and didn't really take into consider reduction of work or layoffs due to COVID-19, and now it does. It's if you are an employee and your hours were reduced or you were laid off as a direct result of COVID-19, you qualify for PUA. This is really important because the department had started to go through and was trying to disqualify people who were reporting partial earnings. So that should be out the window now. And all of these eligibility reasons are retroactive to the loss of work. So if somebody would have been eligible for one of these reasons back in March, April, July, October, they can get benefits going back to that. It's going to take the department a little bit of time, I think, to put this into place. It was just issued, like I said, last Thursday, but this is a great first step in expanding PUA eligibility. We hope to see more from the new administration. So,
Julia, we have a question if you want to take it now.
Sure, I can take it quickly.
If all the documents of employment provided in the 2020, 2020 PUA application and they collected, why is it being required again and payments are stopping?
Because they don't know how to do their education. Like I wish I had explanation for why the department is so bad at their job right now. because people had stopped collecting benefits at the end of 2020, they were no longer in continuing claim status, so they weren't required to just start paying them again when the extension went into place. And so if they are flagging different eligibility issues and want to see documents, they're requesting them now. It doesn't make sense to us. A lot of what they're requesting is already up on the portal. It makes us feel like they're not even looking at the portal. But again, this is just an overall adjudication issue that we're trying to address with the department because what they're doing makes no sense. Wish I had a better answer for you than that. So quickly, I want to touch on mixed earner unemployment compensation because people went crazy when this was announced a few weeks ago. This is a program put in place to try to help people who had both W-2 and self-employment or 1099 earnings who got screwed by being forced to be in the UC program where it didn't count their 1099 income for the purposes of their weekly benefit rate. So if you are a regular UC claimant, right, in the UC system, and you had significant self-employment income in the year prior to applying, then you can qualify for an extra $100 a week. Again, this is for the same time period as everything else. It was for that 11 weeks between December 27th and March 14th. Although I believe this is also on the hook to be extended by Congress. In order to get it, you must show that you earned at least $5,000 in net self-employment income in 2019, most likely through a Schedule C. If you had applied for UC in 2020, now be aware, we have a self-employment disqualification in Pennsylvania. So if that person has not previously disclosed their self-employment to the Department of Labor and Industry, they will investigate them under that provision if they apply to try to get MEUC. So MEUC is best for people who have already disclosed their self-employment and who most likely have a deduction in place because of sideline business work that can now be kind of counteracted by this extra $100. People can apply online, and I believe they need to apply by March 14th for this, and all of the benefits will be retroactive. Again, this is for UC, not for PUA, because on PUA, people already got their self-employment earnings counted towards their weekly benefit rate. Quick reminder for UC eligibility, it's financial eligibility. That's what everyone gets the initial notices on. But then for individuals who were discharged, suspended, quit, have a leave of absence, they're not going to receive benefits often until the department has done fact-finding and issued a notice of determination. They must also all be able and available to work. That really just means able to do some type of work, which counts remote work. However, we have seen a huge problem with examiners consistently disqualifying many claimants under ANA, claiming they haven't proved they're connected to the labor market or that they could do remote work. And that is especially the case with workers with childcare needs. So we are having to appeal a lot of those determinations. These determinations still taking forever for the department to issue. And a lot of times our clients are not even getting really any investigation before they are issued months after the fact. But it's important for them to keep their eye on the mail for questionnaires, pick up every phone call, have a working voicemail that can accept voicemail messages that isn't full, so that if unemployment does try to reach them, the one time they might try to reach them, they can get through. We're also discovering a lot of claimants never received the disqualification that had been issued to them. If a client doesn't know whether they received or like whether they've been disqualified, you should reach out and ask the Claimant Advocate Resource Account if you're a legal aid organization and representing a client. Otherwise, you should send that client or that individual to their local state rep or state senator and have them reach out to see if eligibility has already been determined. Because we want to know if something's been issued, because we might need to have that person file a late appeal. Because if you're denied benefits, the only way to fix that is by appealing. So we talked about appeals in the PUA system. In the UC system, we recommend people send an email to ucappeals@pa.gov or through the online appeal form that's available on the website. They should appeal even if they are beyond the deadline. Because there are lots of different things going on right now that should create good cause for late appeals, especially mailing delays. If somebody got a notice late, they should always keep the envelope because it's entirely possible the postmark date on that envelope may help them get their appeal heard. And it's important that while somebody is going through the appeal process, they continue to file biweekly claims. Last but not least, just a reminder, it's vital that people report income when they are working and collecting. Again, unemployment is about your entire employment and work. It's not about just the job you lost. So people often don't think they have to report income from new jobs they got or jobs they are working in New Jersey or Maryland or Delaware or New York. Not true. You have to report any work done from any employer in any state. And you should report that income when earned, not when paid. Okay, so it's really important to be checking in with people about this and making sure they are doing it. This is what people are going to see overpayments issued for years after the fact, after this pandemic is over, and most likely they're going to be fault and fraud overpayments. So people need to make sure that they are doing this. If you are a W-2 worker, you report your gross income. So in essence, you just take the hours you worked and your hourly rate to determine what to report. In the PUA system, if you are a self-employed, independent contractor, gig worker, you report your net income. So you subtract your business expenses for that week. If you discover that a worker or a claimant has not been accurately reporting their earnings, have them at least email UC Help to report the mistake and explain that they didn't understand, so that if the government comes after them years later, they have proof that they did try to fix it and provide information to the department. And with that, I'm going to go ahead and take questions. I know that there will probably be a decent amount of questions right now, but I'm going to try to hold us to around 15 so that we can then move on to the hearing discussion. But go ahead and ask questions. I do see from Michael Kelly is going to a state rep the best practice for dealing with a long delayed separation determination. So for legal aid, we can contact the claimant resource account to ask the status of a separation, or they can go to a state rep or a state senator. Both have access to the department to figure out what's going on. Unfortunately, we have no way to force them to issue these determinations. And unfortunately, when we try to force them, we often then see our clients disqualified. So it hasn't necessarily worked in our favor. But it is really important to at least have them kind of check in on the progress of that investigation, and most importantly, make sure that a notice hasn't been issued already. Sharon, are you asking about non-fault determinations in PUA? So in UC, when you appeal a determination, when you appeal an eligibility determination or an overpayment determination, it's automatically batched in the back end, meaning that they connect it to any eligibility or overpayment issue. But in PUA, we're not clear that they're doing that. So it's important to make sure that they just appeal everything to make sure that it goes through. Now, a non-fraud overpayment should disappear if somebody is found eligible. I just don't trust the PUA system is set up correctly to do anything. So I do recommend everyone just going in and filing appeals for everything on there. I'm going to talk more about overpayments later today, and we'll touch on waiver as well.
Yes, we have a question from Quinette that was above Michael's. I don't know if you saw it, so I just want to make sure you know it's there.
Okay. I didn't see.
I can read it to you if you want me to.
I see what if the claimant does not have a letter from his or her doctor?
Yeah.
Okay.
I think she just sent it to me. Sorry.
Okay. So to qualify for PUA, the issue about having to quit due to being high risk for COVID-19 or quitting to because you've been told to quarantine or something like that, They're supposed to have a doctor's note per the UIPL from the Department of Labor. We haven't actually seen those requested. We haven't seen a lot of investigation into those types of cases, as long as it's clear on the record, like in their portal somewhere, that they were actually working and then quit that job. We've mostly seen them take the self-certification at face value in those types of cases. So I see a question about working in other states. So the key is for PUA, you need to file in the state that you lost work due to COVID-19, which has been really confusing for folks. And let's be honest, makes zero sense, because this is a federal program. You should just be able to get the benefits from any state. But unfortunately, that's how it's working. So we see people who collected in Pennsylvania and then are told they actually needed to be collecting in Massachusetts, and they're issued a non-fraud overpayment, and the states aren't talking to each other. But if you're advising someone, they need to file for PUA in the state in which they lost work. The same generally applies for UC, except for the fact that if you had only been working in that state recently, you may not qualify financially in that state, in which case we will tell people to go and file in the last state that they worked, where they would qualify financially. And I believe that there's another question about documentation requirements. So yeah, any employment documents from any time in 2019 should meet the requirement if that person filed in 2020. That is what the UIPL says. We will be holding the Department of Labor and Industry's feet to the fire on that one. They do not need to show documentation that they were working in 2020. What we're unclear of is how this is going to relate to the department's investigations about whether someone was connected to the labor market. I think that this documentation requirement speaks very strongly that a connection to the labor market only has to exist as of 2019. But the department has been actively investigating and disqualifying people if they are not showing that they were working in 2020 before the pandemic. And so there's some kind of interesting legal issues involved in all of this that I think we're going to end up addressing in a lot of appeals of disqualifications for PUA. No. Okay, let me, I'm getting another message about filing in multiple states. Let me be really clear. You should never be filing for both UC and PUA at the same time. There is no such thing as choosing which one to be in or filing both. You file in one program at a time. So if you think you qualify for UC in a state, you file for UC in that state. If you get disqualified in that state, you either file for UC in another state, or then you file for PUA in the appropriate state. But you should not be trying to file in multiple places at the same time. I know people did that at the beginning of the pandemic because they were freaked out and no one was getting paid. But they are going to start coming after people for doing that, because now they think people should know better, and people will get hit from fraud with that, because they're most likely going to get paid out on both programs at the same time if they do that. So please make sure people are only filing in one system at a time. Documentation providing claimant lost work due to COVID-19. No. So the new documentation requirement says nothing about the fact that they lost their work due to COVID-19. It's just that they were engaged in work or had plans to commence work. So the only time that somebody might need to prove their loss of work was due to COVID-19 is if the department is investigating them for an adjudication, and what documentation shows that, I think, is still up in the air and is a legal question we're dealing with. But the documentation requirement that was passed in December is just about it's just that you had work or were about to start working in some way. Okay. I think that's it. If anyone wants to unmute and wanted to ask a question verbally, we have a couple minutes and we can do that. Otherwise, I will hand you all off to the very capable Rachel Miller and Aaron Summer for our hearing training. Okay, sounds good. Rachel and Aaron, please take it away.
Hi, everybody. I'm Rachel. I'm going to go first, and then Aaron's going to pick up and fix everything I forgot to tell you all. So we're going to talk about hearings. Can everyone see my screen? Can somebody who's not? Okay, thank you. Okay, so Julia talked a lot about all the issues that lead to hearings. It should come as no surprise that there are a lot of hearings happening. We are having a ton of hearings. It also means the referee offices are having a lot of hearings. So if you take nothing else from this presentation, it is to follow up with the referee offices because their staff are also working remotely. They are overwhelmed and balls are going to be dropped, and ultimately your clients will be harmed. So you want to stay on top of the referee's offices. So let me move myself. So I'm just going to talk about the initial procedures for the hearings after your client, or if you file an appeal, they will receive a copy of that petition for appeal back in the mail. The bottom is filled out by the service center. The next slide will show you exactly what it looks like. What's important for you to know is if you know that your client filed an appeal, you want them to tell you when they get anything back in the mail. A lot of times they will get this back in the mail and they'll say, well, it's just my appeal, and they disregard it and they don't tell you about it. That is not advisable because the mail is very slow. I don't know about the rest of the state, but Philadelphia is still awful with mail. Unfortunately, they're very backed up. So you want to enter your appearance as soon as your client gets that notice of appeal. The referee's office will process it. They have been telling us they can't process it without the appeal number. They used to be able to with social security numbers, but I think it's probably because they're just so overwhelmed, they can't do anything without an appeal number. And it also, if it's been more than 6 weeks, you need to contact the referee's office. Just stay on top of everything, save your communications, because if later on you have a late appeal issue, you will have proof that you tried and that your client did not get anything in the mail. So this is what will come at the bottom of your client's notice for appeal. This part will be, you probably recognize this, it's blank when the claimant fills out the appeal, but when it comes back, it has all this filled out. This is your important information. So it'll say the referee office, it'll say the appeal number, it'll tell you the sections, and it'll tell you the weeks. So importantly, you want to contact the appropriate referee office, and you want to give them that appeal number. And you can find that information on how to contact your local referee office on with a quick Google search. So what you want to do is you want to enter your appearance. You want to request a copy of the notice of the hearing and the referee file. You want to ask for that by email. Because we cannot trust the mail right now. You also want to request all connected appeal numbers. Clients sometimes won't differentiate. If they have notices of hearing, if they get like 3 different packets, they might think they're all the same. They kind of look the same. Again, the referee offices are a little bit overwhelmed. So if you just request one notice of hearing with one appeal number, they may just enter you on that one, even if a client has a whole bunch of connected appeals. You also want to make sure that you have a good phone number for yourself and your client, because everything's by phone. The referees, they're calling sometimes from blocked numbers. People have missed the call. Some people have a block on their phone. They won't take any unknown numbers. So you just want to check with your service provider, and you also want your client to check to make sure that they can get blocked calls. You also want to probably, depending on when it's scheduled, you want to request a continuance, because you have to submit documents 5 calendar days in advance. If your hearing is scheduled in less than a week, that does not give you a lot of time to communicate with your client to submit documents that you want to. You also, again, want to follow up with the referee offices if you do not receive a response to your request. You also want to provide any phone numbers for, if you are having people from your office observe, or any additional witnesses. You just need to communicate with the referee office, because it's not like it was where you could just walk into a hearing room. You have to give them advance notice. So this is what a notice of hearing looks like. This should be familiar to all of you. If not, here's your first one. This has way more information than you could ever expect. It has the appeal number. It'll have the date mailed. That's important because, well, I don't know, to know how late your mail is. the employer's information. It'll have the hearing date and time, specifically the sections. The referee, this will have the referee's email. This is the same email address that you can find online, and the referee's office's fax. Hopefully you don't have any questions about this. Make sure you check the claimant's phone number and make sure that that is the phone number that they have, because a lot of times people change their numbers, or they have call forwarding or something like that. So then you want to review the file. It will be mailed to your client. Hopefully you will get it emailed. We have been told that the referee's offices have agreed to, but again, follow up. It'll include a ton of stuff, prior statements by the claimant and the employer that's been submitted to the service center, any notices and appeals, and the claim record. It's usually at the end of the hearing file. It looks like, I don't know how to, it looks like it was printed in like a different time period. You have to kind of go through it with a very fine-tooth comb, but there's a ton of information on there. Usually the exhibits in the file will be pre-marked by the referee, which is super helpful, because otherwise, I don't know if everyone else is, if other people have printers, but I'm just on my little laptop. So it's very helpful that I know exactly where something is and what it's already been marked. You also, this is just good trial practice. You want to prepare the objections to exhibits ahead of time. You want to pay attention to who wrote what, so that if that person is not there, you can object to anything that they have submitted. And yeah, again, 5 calendar days. So they are very strict on this. If you get notice of a hearing less than 5 calendar days, you need to ask for a continuance if you think there is a potential that you would want to submit any evidence. You also want to make sure that your client has those copies in front of them. You don't want, because you're usually not going to be in the same room as your client, you want to make sure that they are aware of everything that's going to be used. You don't want to be in the situation where your client submitted you text messages that you entered, and then later that you can hear them on the hearing and they're going through their phone and they're trying to testify to stuff that has not been submitted. That will anger the referee. It also will be frustrating to everybody. I just had that happen in a hearing of mine. So just make sure that your client knows exactly what is part of the record or might be part of the record. Also, if you submit stuff and then perhaps maybe for impeachment, that person's not there, you don't have to offer it into evidence, but you just have to have it available to the referee, because again, you can't just have it in a folder on the hearing file, on the hearing table, and bring it out if you need it. It needs to already be out there so that you could potentially use it. Also, if the referee or the employer starts referring to a document you do not have, you have to speak up and object. And I know I've been repeating myself, but the referee's offices they're overwhelmed, and they may not have sent it out, or if they did, they sent it in the mail. If people don't have documents, that you have to object. You have to ask for the record to remain open, to continue the hearing, or it needs to be kept out. And make a record. The referee's going to make whatever ruling they will, but if you have to appeal to the board and get a remand, that's something that you might have to do. So you want to make sure that your client is familiar with the file. I know the first few times I looked at hearing files, I did not know what most of those documents were. So your client is likely not going to either. You want to review all parts of the file where your client made any statements, and you want to prepare your client for those inconsistencies. You also, again, want to have your client have all of the documents that they may testify to near them, that they know what they are. If you are planning to use the claim record, make sure that your client is aware of exactly what they're going to be talking about. This is a huge problem with phone hearings. If your client is not a native English speaker or English reader, you need to work with an interpreter. Otherwise, it is very, very difficult to have a fair hearing if your client does not even know what documents are in front of them, because they're all in English. So prepping your client for the hearing, there's no discovery. Basically, what you get is what's in the hearing file. Your client is often the only source of information. So you really want to prep the client. Client prep is so important in these phone hearings because they don't get the benefit of nonverbal communication with you. They cannot read your body language to understand if you want them to stop talking or elaborate or anything else. So they really need to understand how the hearing's going to go, what the steps are, so that they are not just lost alone in their own house. You need to make sure that they are comfortable, and you need to be comfortable with your client's story. So this is just general hearing practice. You want to identify the area of the law that the hearing is going to be about, gather all the facts, the documents. Obviously, you want to submit them. You want to know the rules and procedures of the hearing, and you want your client to know those rules and procedure. You want to practice running through questions with your client. You cannot tell your witness what to say. Please do not give your client a script. Remind them that they are under oath. And you want to identify any issues in your case. So you don't have to bring out on direct some inconsistencies, but if those inconsistencies are there, you need to prepare the client how to respond to a question if the referee or opposing counsel asks them about it. So there's two main areas, and this is just for a separation hearing. If discharge, you want to look at the reasons for discharge. You want to identify all statements offered by your client and the employer. You want to identify objections, good cause. You need to figure out if you have bad facts that you need to deal with. So I would encourage everyone, if you're not familiar with the PBI manual that comes out every 2 years, that you look at that closely, especially in the specific area law. There's a ton of helpful blurbs and case law for you to look at to know what law would apply in your specific case. And then for voluntary quit, did they actually quit? Oh, sorry. The reason why they quit, usually only want to offer one legally relevant reason. The same way that employers that give a whole laundry list of reasons why they fired somebody, it's also not that helpful if a client just, airs all of their grievances about the employer. You want to, if there's one that's good enough, you want to kind of stick with that. You also want to identify exactly what your client told his employer, and you want to look at evidence of that. So if they had text message conversations, or if your client has call logs, if there is a letter that they submitted to resign, you want to submit that information. You also want to identify the employer's response. Aaron's going to talk a little bit more about hearsay, but if the client approaches their employer and they're not, and then the employer tells them something, that is not hearsay, because that is a statement of a party opponent, and was an accommodation offered by the employer after the claimant told them, I can't go to work, or I have this issue with work. And for able and available, Julia talked a little bit about this, but usually comes up with voluntary quit cases. They don't have to be able to work out of the house in order to qualify for benefits. So you want to prepare your client to answer questions about what jobs they would be able to do and whether those jobs are available. Referees and the service center are kind of going after people, especially when claimants have to remain home to watch their children. You want to really tread carefully here, especially people who have young children. If they say, well, I have to watch them 24/7, they're always getting into things, that's going to cause the referee maybe to find them not able and available, because they really probably couldn't work if they're watching a couple of toddlers at home. You also, if the referee starts asking questions that go to ANA, you can object to jurisdiction if it's not on the hearing notice. It's helpful if claimants can identify specific jobs they have applied for. They don't have to be applying for jobs right now, but it is helpful to help corroborate that they could work if they found a job. So telephone hearings are a lot more work than regular hearings. It's been my experience. You want to prepare your client very, very well. You want to review the hearing procedure. You want to explain that they need to speak slowly and clearly. They should not interrupt anybody. You need to answer the questions directly. This is really important. They want to be prepared to answer those background questions easily. That sets the tone for the whole hearing. So you know what those questions are. It's the first day of work, last day of work, rate of pay, full-time, part-time, and quit, fired, or something else. So your client should be prepared to answer those questions very easily. If they don't know the first day of work, that's okay. They just shouldn't fumble around. That really will irritate referees. They also should keep their voice up and wait a few seconds after a question to answer. They should stop and think about the question. And obviously they should be in a quiet place, have their phones charged, and if possible, arrange childcare. The referees have, and they should be nice about this, but I've heard some stories about referees getting very frustrated if there's, a child in the background. So the best that they can to be quiet and to be in their own place, that is helpful. And these are specific to phone hearings. Sometimes employers are reading off of something not in the record. And sometimes it sounds like the employers and witnesses, especially if they're all in a conference room, are communicating during the hearing. If you think this could be happening, you need to say something so that the transcript picks this up. Sometimes the referee will say, okay, I don't really care. You have to play to the ref. They're the ones making the calls. You want to be patient with them. They have a lot more work. They also do not love phone hearings. But ultimately, if you lose at a referee hearing and they made a wrong call, you do have the benefit of an appeal. So there's no benefit to arguing with the referee after they made a call. And then, the day of hearing stuff, you just want to make sure that your phone and your client's phone, again, can receive calls from blocked numbers. You want to check in with your client because if the referee calls you and they're saying, we've been trying to reach your client, we can't, you can say, I just texted with them an hour ago, like, please try them again, or let me text them and let's try to make this work. You want to make sure that your client knows they should not start the hearing without you. This happens way more than it should, but your client needs to know that they have to advocate for you to be on the line. There's a lot, it's pretty overwhelming for clients. The referees talk very quickly. People just want to agree. Just tell them if there's one thing you remember, it is to make sure that I am on the line. A lot of times the hearings do not run on time. You have to stay by your phone. The hearing notices always say that the hearing could start 15 minutes before the scheduled time. I've never had that happen, but you should just tell everybody you should be by your phone 15 minutes before. If 15 minutes have passed and you haven't gotten a call, you should just send an email to the office to ask them what's going on, but that happens a lot. You could get a call late. The hearing before you could have been 2 hours instead of 1. So this is important. If the employer doesn't attend the hearing, the discharge case, it should be a very, very short hearing because the employer has the burden of proof. If the employer is not there, they cannot prove anything. So you want to object to any document that's been submitted by the employer. It's all hearsay. No one is there to authenticate it either. You want to appear reasonable, but if the employer's not there, you want to object to everything. You also want to be you don't want to ask your client much. You want to ask them 2 questions. Sometimes the referee will ask the questions for you. The questions are, did you knowingly or intentionally violate any work rule? And did you perform your job to the best of your ability? You don't want your client to testify about anything else. If they were fired and they actually had good cause, that would be great if the employer was there. But if the employer's not there, they don't even meet that initial burden. So you just want to prepare your client to not get upset if you only ask them 2 questions. You'll tell them about this in advance. If the employer's not there, this is a very easy hearing. They can hang themselves, but you don't want them to, so you need to prep them. If it's a voluntary quit case, you have the burden. This doesn't really change much if the employer is there or not. Your client has to testify to meet that burden. You can still object to any employer's documents, and you can use the employer statements against them, even if they're not there. What they told the claimant is still fair game. And if the employer's not there, the referee sometimes will be adversarial. So they may be cross-examining your client. Client should be prepared for that. They can do that if the employer's there as well. So now I'm gonna stop sharing and Aaron's gonna talk about hearing practice, although if there are questions, it looks like there's a couple of questions in the chat. While he's getting set up, I'll look and see. Okay, so if the claimant does not speak English and the referee's office cannot locate an interpreter in the necessary language, they have to. They have a service, they have to call and set up a referee. They have to set up interpretation. We have had some issues with that. So sometimes they call, I don't know what service they call, but sometimes they call and the person on the other line does not know that it's hearing. They've said, oh, I have an appointment in 10 minutes. So it's a whole thing, but they have to. That is a requirement. It is a violation of the claimant's due process if they cannot get an interpreter in their language. Yes, referees have supervisors, and that sounds like, Deborah, that sounds like you should ask for a remand, but yes, if your notice is in the file, they never called you, that is a violation of your client's rights. They do have supervisors, but really the best way to handle this is for appeal to the board and ask for a remand. So with that,
also, Rachel, I'm just gonna hop in for a second.
Yeah.
If people are having situations like that, I'm actually gonna ask you to email Rachel and let them know that has happened, because we are trying to track all of the problems happening with telephone hearings and report them to the board administrator. And also because there's going to be a big push, as always, to move to telephone hearings even after the pandemic, we want to collect all of the examples of how much these hearings really don't work for claimants. And so if you have crazy situations like that, it would be good to reach out to Rachel so that they can track what is happening.
I'll share my email address in the chat.
While we're working on this transition, this is Kelly, and I'm going to go ahead and launch the second CLE poll. So attorneys, please respond for CLE credits for this hour of training. I'll leave it up for 2 minutes. Thank you.
Okay, can you see the slides?
Yes.
Yes.
Okay, sounds good. All right, so I am Aaron Summer. I am a staff attorney at Philadelphia Legal Assistance also. I'm going to talk about hearing practice, so specifically what you're doing in the hearing. So at the beginning of the hearing, the referee, after they call all of the participants, the referee will have everyone say and spell their name for the record. They'll ask if everyone understands that the hearing is recorded, and then they will get into reviewing the rules and sections of law at issue, and they'll ask if you, as the representative, are aware of the claimant's rights, and if the claimant is aware of their rights. They will then swear the witnesses in. During telephone hearings, there are two, they have to be sworn in for 2 oaths. The normal oath to tell the truth and the whole truth, and then they also have to swear that they will not be testifying based off of documents or prompted by someone not participating in the hearing. The referee will then go through all of the documents in the file. I think, like Rachel mentioned, a lot of the referees are marking the exhibits in advance, but not always. So it's important to follow along during this and make sure that you keep up and keep track of which documents are numbered, which number. Once the referee has gone through all of the documents and identified them for the record, you'll have the opportunity to object to documents before they're entered into the record. The referee will then usually get some background info from the claimant and employer, and then it will move on to direct examination. If it's a discharge case, the employer will be testifying first. And if it's a voluntary quit, it'll be the claimant testifying first. So on direct examination, your job is to help your client tell their story. And so you should be asking open-ended questions on direct. So those questions are, who, what, where, how, and why. So those are questions like, what happened after you arrived at work on that day? Or who told you that you could leave early? When you're going through direct examination, you should be listening carefully to how your client is actually answering the questions, and ask questions that respond to those answers. It's important to plan in advance of the hearing and sort of have an idea of what questions you want to ask, but that doesn't mean that you should be following a script. You want to make sure that you're on the same page as the witness, and that if the witness hasn't actually really answered your question, you need to follow up and make sure that you're getting that information that you want into the record. You should plan an order to your questioning that makes sense, either chronologically or some other order that might be dictated by the section of law or the legal issue that's at issue in the case. You should only ask questions for relevant information. Try not to get into sort of extraneous or side issues that aren't really going to be on topic, because the referees are trying to move these hearings along, and they don't have a lot of patience for sort of going into things that are not obviously relevant. Like I said, you should prepare your questions ahead of time, but don't necessarily follow a script. You should be focusing on the personal knowledge and experience of the client. What did they do? What did they experience? What did they see? What did they hear? What did the employer do? What did they tell them? Use exhibits to help support your client's story. So this is, you're submitting documents 5 days in advance, and those documents can be used to add weight to your client's testimony, or they can be evidence that proves something in the case. But you should make sure when you're submitting exhibits that they actually have a real purpose, that they prove something that you want to, that's necessary to the case. If you have additional witnesses, you will also have the opportunity to go through direct examination with them. You should think in advance about what objections you may get from the employer, and sort of prepare for how you're going to respond to those objections. Signpost, loop, and listen. 3 random words. So these are techniques or good practices when you're in a hearing and going through direct examination. Signpost is when you're questioning your witness, and you provide a bit of context or a header when you're asking a question. So you say something like, "I'd like to talk to you about your medical problems," or "Now I'd like to speak about the day of the incident." And so this gives both the referee and the witness a bit of a heads up to where you're going, and it can provide a bit of it'll perk them up a little bit. It'll make it clear that this is going to be relevant and important information. Loop is it's when you are questioning your witness and you're basically repeating information that they have just testified to. So, for example, in a case, if your client testifies that, then my coworker called my mom a pig, then you can ask them in response, "Well, what did you do when your coworker called your mom a pig?" Or if you say that, if the witness says that they gave the employer paperwork and they told them that they could go home for the day, your question follows up after your employer told you to go home for the day. Were you in contact again? So it repeats important information so that it's clear that that information is in the head of the referee, and it just really emphasizes those points. Listen is really just a reminder that you should be listening to what your witness is saying, and not just following a script in asking your questions. Your questions should be based on what your witness has just said. And so, as I said, it's good to prepare in advance, but that those questions that you prepare in advance should really be more of a loose outline rather than a script. Cross-examination, when you're going through cross, you should be asking leading questions only. So these are questions that are really providing an answer or a statement and giving, so examples are, you didn't see the claimant arrive at work that day, correct? Or isn't it true that the claimant told you that they would need to pick up their children from, or leave early to pick up their children that day. When you're going through cross, you should be very careful not to ask questions that you don't know the answer to. You know, if you're not sure how the witness is going to respond to a question, you probably shouldn't ask the question. There are no depositions or there's no discovery in advance of these hearings. So you don't go into them with a ton of information other than what your client has told you. So a lot of times it's, it may be better to keep your cross-examination pretty short. The questions themselves should be short and concise and really just have a single point in them. So during cross, what you're trying to really control what the witness is saying and the pace of the exchange, but you shouldn't speak over them or cut them off. Repeating, so looping and signposting work here as well. And it's, these hearings, these phone hearings are a bit different from in person. And I think anything where you're able to repeat and emphasize information for the record will be helpful. Don't get flustered if the witness isn't, cooperating or answering exactly how you thought. You should, if you have the opportunity, you can use the documents in the service center exhibits to impeach on cross-examination by showing inconsistencies with their testimony, or just showing that something they said is that they didn't include in their testimony. You really should be focused on trying to undermine the employer's case on cross. You're not necessarily trying to prove anything on its own. That's what your client will do, but you don't need to be asking questions to try to get employers to admit something or prove a particular point. At the end of the hearing, some referees will ask for a closing argument. Some will just ask the witnesses if there's anything else that they would like to add. It's very dependent on the individual referee. If the referee does not ask if you would like to give a closing argument, you can always ask. And when you're giving a closing argument, you're really just trying to provide a summary of the important points, explaining why your client should prevail. Let's see. Okay. So during these hearings, the rules of evidence are applied somewhat liberally, but it's important to object as if those rules are going to be applied strictly. The referees don't always know the rules of evidence all that well, but a lot of why we object is to create a record for an appeal if an appeal is necessary. When you're objecting, you should be objecting with a single statement. So you're saying objection hearsay or objection relevance. And if the referee asks for more, you can explain the objection, but a lot of times that they will understand what you're objecting to. So you can object to almost anything during a hearing. You can object to a question, you can object to an answer. It's a bit, I don't know, risky to object to the referee's questions, but sometimes it's necessary. You will want to be a bit more careful about those because they don't particularly like when you object to their questions. You can also object to documents whenever those are being admitted. During these phone hearings, documents are only going to be admitted at the beginning of the hearing, usually. So going through some of the common objections, relevance is you're really just objecting to some testimony or evidence and saying that it's not relevant, or that it doesn't actually prove anything that's necessary for the case. So employers often want to go into lots of stuff that doesn't actually really help anything or progress the case farther. It doesn't make any sort of fact relevant to the outcome more likely. They often are providing, old disciplinary reports, or they will provide, performance reviews when the issue is not whether someone was fired for good work or poor work performance. Let's see. Okay, so foundation is an objection you would use when the evidence that's, you're objecting to the evidence on the basis that we don't know where, the origin of the evidence. How did the picture get taken? When was it taken? Who took it? What's in the picture? You can use this for testimony or documents. If it's testimony, you're saying that you don't know how the witness knows what they're speaking about. How do you know that that person didn't come to work that day? So this is a helpful objection, also probably mostly with documents, though. Speculation is an objection where the employer or where the other side's testimony is saying something that they can't really know, or that they didn't personally witness. An example is if the employer is testifying about your client's motives in deciding not to attend a training. or if they're saying that they knew what someone else is feeling or thinking, that's usually going to be speculation. You should try to avoid having your client testify to things that will be speculative also. So like we said earlier, you want to have them testifying to things that are, that they witnessed themselves or that they experienced themselves. Hearsay is probably the most important, the one that really comes up the most and has the biggest impact on these hearings. It is an out-of-court statement offered for the truth of the matter asserted. So the idea is that if the person who made a statement or is not present in the hearing, or if then that information can't be you can't be evaluated because you can't cross-examine that person, you can't question that person about what they said. So hearsay can be used on documents or testimony. There are lots of exceptions and exclusions from hearsay. Generally, statements that are offered for some reason other than to establish the truth of the statement, they are usually not going to be considered hearsay and should be allowed. So some examples of these are if you're testifying to someone's or about someone's state of mind, or testimony that shows that someone intended to take certain action at some point, those are, should be allowed in, even if the the statement is an out-of-court statement. I think Rachel mentioned earlier, statements by a party opponent are an exception to hearsay. This generally comes up when the claimant is testifying about something that an employee of the employer said when that person is not present in the hearing. So if they're testifying about a supervisor that they spoke to who's not at the hearing, and the employer objects to hearsay, the response is that these statements are an exception as a party opponent statement. I think it used to be called an admission, but they changed how it was referred to a party opponent statement. Business records are another exception to hearsay. So a lot of times the employer will want to provide records and argue that those records are business records, but you should be watching to make sure that they were made by someone with knowledge of the incident that they're speaking about in the regular course of business. The fact that something is a business record also does not necessarily establish that the contents of that record are not hearsay. So lots of records may be hearsay within hearsay. So you should watch out for that, because if you're looking at a document and it's a form where someone filled in parts of it, there could have been two different creators, or they're talking about, if the written statement has a quote from someone else saying that someone else told them certain information, that's going to be hearsay within hearsay. So the business record exception may allow them to get the actual record into evidence, but it doesn't necessarily establish that all of the record's contents are admissible. Like I went through this a bit earlier, what a leading question is. Leading can also be a basis for objection. You would object if the employer is leading their own witness. You are not supposed to lead when you are going through direct examination of your own witness. You should, don't be overly aggressive with this objection, because it will sort of just make you look like a jerk. Let's see. Okay. You can object to questions. This is something that comes up somewhat regularly. Asked and answered is when you are objecting to someone sort of asking the same question over and over again, where the witness has answered the question already. Argumentative is where they essentially are arguing with the response of the witness, or just continuing to go back and forth about an issue. Badgering the witness is just being overly aggressive, or these are all sort of the same thing. Vague is when you are, they have asked a question that's not clear, and it's not clear what they're asking or what they're getting at. Compound question is when they're asking two different questions. So if they say, did you attend work on Thursday, or did you decide to stay home? So that would be a compound question, because if they answer yes, it's not clear what they're responding to. When you're offering exhibits into evidence, you want to sort of draw attention to what you're going to be presenting. Say something like, I am looking at this document marked Claimant's Exhibit 2. And then you will ask the witness to identify the document, explain what it is, essentially, and then you have the witness testify that it is a fair and accurate copy of that document. When you offer exhibits, you should be offering them as Claimant's Exhibit 1 or Claimant's Exhibit A, but make it clear what the document is, and provide a clear title for it, or marker for it. When you're providing documents into evidence, you want to be prepared in advance for objections. So think about that and think about how you would be responding to try to get those documents into the record. After the hearing, you want to speak to your client briefly to just, provide a summary of what they should be doing from that point. So they should continue to file their biweekly claims. Keep an eye on the mail. The referees are still mailing hearing decisions. Sometimes it takes a while these days, but generally it's going to be within a week or two that the decision will be mailed out. You should have your client notify you as soon as they get the decision. If the client's benefit status changes, they should tell you. That may be an indication that they, that the referee's decision was issued and that they, you haven't received it. It might be a hint of what happened, and you should follow up with the referee's office. Okay, so we just wanted to do a brief demonstration at the end of this, just for everyone's benefit, to show exactly how you can access the hearing file for Pua Appeals. For those of you who haven't done this yet and may have some of these hearings coming up. So briefly, you will begin by logging into the claimant's Pua portal. Once you're on the dashboard of that portal, you go to the top left and you click to open the side menu. From there, if you click on Unemployment Services, it will open up a different menu where you can click on Appeals, and that will take you to the appeals page where there will be different tabs at the top here. And one of them is Appeals. And if you scroll down, there's an option to view the appeal file, and that will open up another window that will have the appeal file that you can download. And that's how you do that. It's pretty self-explanatory. So that's all we got.
So we'll take 5 minutes for questions, then we're going to take a 10-minute break to let everyone grab some more coffee, run to the bathroom, do whatever, and then we'll come back for the last session. So if anyone has questions for Aaron or Rachel, put them in the chat now, or go ahead and unmute yourself. Okay, then with that, it's 11:03. Why don't we see everyone back here at 11:13, and we will continue with the rest of the morning session before breaking for lunch. Thanks, everyone.
Just to note, everyone, you don't need to sign out if you don't want to. You're muted. If you want to turn your camera off, feel free to stay signed in.
than what they should have received. So when we have a fault overpayment, they typically disqualify someone with wage reporting for the entire week, right? So if you didn't report, the $200 worth of income you had, and so therefore you received $500 worth of benefits, then if they found it's a fault, then you owe them the $500 back. But if it's a non-fault, and you still would have received most of that $500 because of partial benefit credit in that week, then you only owe the amount that you shouldn't have received based on the income you didn't report. So it should be a much smaller overpayment in terms of the total amount of money. And the Service Center doesn't always get this right. So it's really important to look closely on these wage reporting cases to make sure that the math is actually done correctly, and to make sure that the referees are doing the math correctly after a hearing. Fault overpayments are, of course, the ones that we are terrified of. These occur and are issued under Section 804A. The language is just any person who, by reason of his or her, or we'll say their fault, has received compensation they weren't eligible for. Fault overpayments, unlike non-fault overpayments, accrue interest at a rate determined by the Department of Treasury. For the longest time, that was 9%. I believe it's lower now. But they can also fully recoup fault overpayments by deducting 100% of future benefits for a 10-year period. That's the current statute of limitations, the statute of collections on recoupment for fault overpayments. Although if you're talking about an old overpayment that was before, June 2012, it was a 6-year statute of collections. So they can take, like I said, the entirety of your overpayment amount, but they can't take any sort of interest or penalties assessed against you without permission from the claimant. So they have to otherwise stop recouping once they get the principal. They can also intercept people's tax returns to the Treasury Offset Program, file liens and judgments against them in the Court of Common Pleas based on unpaid principal and interest. And sometimes they do send these cases when it's fraud, when it has additional penalties, to the local district attorney for prosecution. They are misdemeanor cases. For the liens, it's just important to make sure people know they do not show up on your credit report. But if somebody's trying to get a mortgage or a loan and somebody does a search for judgments, they will show up. Those liens stay for perpetuity. They don't go away. And so the only way to get rid of them is to satisfy it by paying it back. However, it doesn't really affect most of our clients because generally it attaches to property issues. And so maybe if they own real property and they're selling it, it could, be used to lower the amount they receive from any sort of sale. But sometimes it doesn't actually attach to the property. They're just not set up very well. So, we encourage people to pay these back because of the various consequences. But if somebody can't, then there's very little that it will do to impact a vast majority of our clients. They cannot there's no wage garnishment in Pennsylvania. They cannot garnish or intercept any other sort of federal benefits like Social Security benefits, just what you see up here on the screen. Now, fault overpayments are not defined in the statute. There is no definition of fault, but it has been made very clear that fault in order to establish fault, the department has to find, in essence, a culpable act, right? That they actually did something to which blame, censure, and propriety attaches, right? So we're talking about a blame worthy act, and it really has to do with showing the claimant's state of mind. So there has to be a finding on state of mind. Generally speaking, the board has been applying the same kind of standard for fault and fraud penalties, which is if they haven't, intentionally misled the department or, intentionally withheld and knowingly withheld information, then it will be a non-fault overpayment. Every once in a while, we see them find a fault overpayment, but no fraud penalties because they didn't intentionally withhold information. from the referee. We'll often appeal those to the board, and they'll usually agree that that shouldn't be a fault overpayment either, which means there's really not a lot of light between fault and penalty fraud provisions in our law, which we're okay with at the moment because we don't want the standard for fault to be lowered at all. And so that's generally what the argument is going to be in a lot of these cases, especially with wage reporting cases going forward. I think, like I said, we're going to see a lot of those. If it's a complicated question of what the wages are, if maybe the wages were wrongly reported by the employer, it's very helpful to have someone represent that claimant in a hearing. But if the claimant just didn't report because they didn't realize they had to report, those clients are sometimes better off going on their own to the hearing because they are more sympathetic and better kind of showing their confusion about the system than when they're represented and we're asking, well, did you intentionally withhold information from unemployment? And then the referees just think that like we prep them to give them all those answers and are less likely to find them credible. So seriously consider as you're talking about priorities over the next few years, that in some of these wage reporting cases where people just didn't understand or didn't know, prepping them to go on to the hearing on their own might actually be a more effective type of advocacy for them. And again, mere mistake, confusion should not cause a fault overpayment. That's the big thing we're going to be arguing for the next several years in all of these overpayment cases, especially in PUA, right? Like a lot of people just didn't understand what the eligibility requirements were. And if they answered everything truthfully on the application and they were paid in PUA and then later found ineligible, they should not have a fraud overpayment. They should have a non-fraud overpayment. I'm throwing those, and of course, penalty weeks are still around. This has been really harmful to claimants during the pandemic. Penalty weeks are in essence dead weeks that people have to file where they don't get paid. We have issued a demand letter to the Department of Labor and Industry about the fact that they have not let people on penalty weeks file in PUA, which we believe they should be eligible for PUA, given that they are ineligible for regular UC. They also didn't receive the extra $600 or $300 for this week. We are right now hoping and waiting that the Federal Department of Labor may adjust previous guidance on this to make it clear that these workers are eligible for PUA during these weeks. And so we are waiting to see how that shakes out before pursuing the litigation further. We've been tracking our clients who have lost thousands of dollars due to the penalty week issue, so that if there is a change, we can immediately notify people of that to try to get them access to benefits. So I've been throwing around a lot of terms. Just to be clear, for the federal programs, right, we're talking PUC, PEUC, PUA, they use non-fraud, right? Non-fraud equals non-fault, and they use fraud. Fraud equals fault for purposes of Pennsylvania law. And that's because the federal program overpayments are still governed by state law, right? So they can only be collected consistent with the recoupment provisions of our state law. Now, there have been several different issues with overpayments in the UC system. First, we've had a lot of people who have overpayments that are outside the statute of collections, so they can't recoup them. But in our old mainframe system, there's still a hold on those benefits because of the old overpayment, and so claims must be manually released, which is really annoying and has held up benefits for folks a lot of the time. They often do go in a manually release, but it can be like a week, 2 week, 3 week delay for a lot of people. If this is happening continuously with someone or it's been quite some time, we recommend reaching out to the department about that. If you're trying to figure out how old someone's overpayment is, one method to do that is to search Court of Common Pleas dockets for liens or judgments against your client. It'll be Commonwealth of PA versus your client's name. One piece of information that has been incorrectly given out by the department, often by reps on the phone, is that if you make a voluntary contribution to your overpayment that is outside the statute of collections, then your overpayments will just be released timely every week. That is not true. The head of benefit payment control has confirmed for us that voluntary contributions have no such effect. There is still a hold on people's benefits. And in essence, this just feels like coercion to try to get people to pay money on overpayments that the government can't come after them for. One thing to note is that overpayments, and we emailed about this recently on the plan listserv. So the extra $600, extra $300, overpayments do apply to that. So a non-fault overpayment should result in a 1/3 offset from the PUC. And if it's a fault overpayment, they can't take the full thing, but they can take 50% of it per federal law. That's how it's supposed to work. How it's been working in Pennsylvania, and we don't see it changing anytime soon, is that our old unemployment compensation mainframe system can't figure out how to pay people different amounts of supplement. Therefore, everyone, regardless of having an overpayment or not, is just receiving the full PUC. So they've been receiving the full PUC since the summer. They're receiving it now. It's unclear to us if that's going to change, if at some point they might issue overpayments for that. Very unclear, but in the meantime, it's working out well for our clients if they're getting the full amount of the supplement. So we are also starting to see, as we talked about, a lot of determinations in the PUA system. And so, of course, those are leading to overpayments. Overpayment determinations will show up in a claimant's message center. It should be there as, in essence, like an email message with the overpayment notice attached. You can also find them by going to the unemployment services section in the menu, and then the appeals tab, the appeals section. And once you're in that, there's a tab at the top that says determinations. I'll also just note, we keep talking about going into people's portals. I know that this is not anyone's preference. We don't love collecting information for our clients. If you don't feel comfortable navigating your client's portal without them and collecting their login information, which of course we only keep in our secure client management system, you could try to Zoom with a client or do some sort of screen share where they're on their portal and able to show you what's going on. The vast majority of PUA overpayments so far have been non-fraud, which we are glad to see. We were really worried about that at first. The vast majority are due to disqualifications on eligibility. In essence, they're just looking over claims and deciding that people weren't eligible for the benefits they were paid for. And so they're issuing non-fraud overpayments. We are starting to see some fraud overpayments. Every once in a while, we've seen one where they are claiming somebody lied on their initial application, but they don't provide any more information than that. So we have no idea what they're claiming the lie was. And then we are seeing fraud overpayments in those cases where somebody received both PUA and UC at the same time. In essence, they were filing in both systems and getting paid out of both systems at the same time. Not like they accidentally filed in one and it paid them for all the same weeks they had gotten UC and things like that, but they were actively filing in both and receiving both at the same time. It's going to be really important to appeal those fraud overpayments and help your client understand how to explain what their confusion was, why they did that. Again, it's an interesting question about whether it makes sense for us to be at those hearings or whether they're going to be more sympathetic without us. But I'm also looking into, what sort of resource could we give advocates or claimants to point to that shows like this is a widespread problem, right? It's not just this person who did it. Lots of people made this mistake. And also the system should have caught it from the get-go. And so they never should have gotten paid. So we're trying to think about what we might be able to get out there publicly that people could point to help with that. So one thing I wanted to alert everyone to is that there has been a significant overpayment issue in PUA with how offsets are happening. So the PUA system has been incorrectly applying these offsets we've talked about. This all started back last summer in July with what we call the Gsi Double Pay Issue. This is when Geographic Solutions Incorporated, the vendor for the PUA system, accidentally somehow double paid 35,000 claimants for 1 week of payment, meaning that those claimants, if they had received multiple weeks of payment in that 1 week, those multiple weeks all got reissued again. So this led to some significant overpayments for folks because it also caused them to get the extra $600 again. These are non-fraud overpayments, but then the system began offsetting 50% instead of 33%. And then at some point cut claimants off completely from benefits in the fall, so they did not get their full 39 weeks. We've been raising this issue consistently with the department, and the issue is now even more widespread. Claimants are receiving notice or seeing on their portal that they have exhausted their benefits, even though they haven't received their full 39 weeks in 2020 or a total of 50 weeks now. And that's because the system is saying that they previously received more money than they were eligible for. So like those GSI Double Pay clients, because they received a double pay of their PUA benefits, they're counting that against their benefit allowance and saying, oops, sorry, you early exhausted your benefits. Or for instance, claimants who had a downward adjustment in their weekly benefit amount. So they were originally getting $400, but they didn't have the documentation to back it up. So it got downgraded to $195. The system saying, well, we paid you all that money earlier, so you early exhausted your benefits. Let's be very, very clear. There is no such thing as early exhaustion of benefits. The way that this should work, and the only way it can work legally, is that when that happens, if somebody receives benefits they were not eligible for, they should be issued a non-fraud overpayment and then have a 1/3 offset. In essence, what they're doing is trying to squeeze claimants at both ends, especially if they do have an overpayment determination and we're taking 1/3 and then doing this early exhaustion bit. Some of these claimants, especially the ones who had the downward adjustment, like don't even have an overpayment determination. They're just getting a message that says exhaustion. And this is a real problem, not only because people didn't receive all their weeks in 2020, but it's prevented a lot of claimants from getting any payments in 2021 and getting access to the extra 11 weeks, or it's cutting them off early for the extra 11 weeks. Again, we have been on DLI about this change for months, and the problem, I will say that this week we got indication that progress is being made, that they do seem to realize this is a programming error in GSI, all of these aspects, and I believe are working to fix it. So as soon as we have an update for folks, we'll let you know. In essence, this is a system problem. So if you have a single client experiencing this, there's really nothing we can do to change it with the department. They have to fix it on a system-wide basis. And so it'll get fixed for everyone, not just our clients or people that we've made them aware of. So one of the things I wanted to quickly go over, because there's been some talk about it as well, are what the department often refers to as internal overpayments or cross-program overpayments. So that happens when DLI moves people who are in the wrong program. So they see that somebody is in PUA, but they see they should have been eligible for a UC claim for that period. Or we have a lot of people who filed for PUA because it was available before PEUC availability was announced. And so they were collecting PUA when really, because of an older unemployment claim, they could have gotten PUC and EB. And so what the department is doing is they're moving things over, they're building the UC claim. And then for the weeks that somebody had received PUA, they're in essence doing a total offset for those weeks in the UC system, which they're calling an internal overpayment. They're in essence just moving the money between PUA and UC to in essence prevent there from being any sort of real overpayment there. And for some clients, it's actually an underpayment because they might have had a higher benefit rate on UC than they had for PUA. But it often looks funny in the system because if you log in and look at the benefit payment history in UC, you'll just see like overpayment offset and it's 100% offset, which looks odd because it's a non-fault overpayment. But they're just moving money around in the background, and that prevents our clients from having much of an overpayment. The thing that's confusing about that is that it doesn't change the number, like the amount of their overpayment listed on the PUA portal because the systems don't talk to each other. So people are seeing that they have an overpayment of like $14,000 in their PUA portal, when in actuality, it could be like $700, right? Because of how the internal offsets end up working. And generally they don't have what's called the PUC overpayments because they were eligible for PUC on the UC claim. So it's really difficult for people to figure out. We've reached out to the department and their federal programs team to figure out how they can make this reflect more accurately for folks. And also, like, we don't want those overpayments to sit in PUA at the total amount and not change in that system in case that causes other problems. But again, everything is just a little bit of a mess right now, but we do think that they are often handling these internal transfers and overpayments correctly. I've seen a lot of cases where they've done this accurately, and so that is generally a good thing. If there are any weeks that somebody filed on let's say for any weeks not filed, I meant not filed on UC, sorry. So if somebody had filed for weeks in PUA, but they weren't eligible for those weeks in UC, then they can offset, again, 1/3 of that week when they pay it out in the other program. So the internal offsets only apply to weeks that were filed in both systems for the same week. It's not happening in the opposite direction. We have not really seen UC overpayments being offset against new PUA payments if they move programs. They just continue to have kind of the non-fault overpayment in UC. So it only seems to be going one way right now. Unclear if that's going to change or if that might just be because of limitations with the PUA system. Before I get to waivers, one other note on this, as I said, in the UC system, the PUC payments are not being offset, but they are being offset in the PUA system. So people who do have these non-fraud overpayments are getting 1/3 of the $300 currently offset. So that is correct for everyone. They're correctly able to do that at 1/3. Don't know why they can't correctly do the regular PUA benefits at 1/3. But that's so, but that is actually happening in terms of an offset in PUA. So finally, it's been made clear to us by the department, even after months of us asking them about this, that they are re-upping a program they were able to use during the recession to have waivers for the federal programs, even though we don't have a waiver provision in our state law. So waiver is available for non-fraud overpayments for the federal program. So that's PEUC, PUC, and now PUA. PUA was not previously applicable for waiver, but that changed in the December extension. And so PUA can now be waived. Under federal law, waiver should be granted if the repayment would be contrary to equity and good conscience. Not further defined, really. It's been further defined by other states. And I actually do think, I'm going to have to look it up because it's been a long time. I do think that we have some case law in Pennsylvania about this from the recession. The department is not advertising waivers. They're not doing anything to make this well known. I think because their opinion is, well, you know, a lot of people are going to apply for waivers then who are not eligible, and it's just more work for us, which is really awful because these waivers can be really vital to people. The waivers are coming in the mail often along with notices of determination of overpayments for PUC or PEUC on the UC side, but some people are not getting the waivers in the mail, so it doesn't seem to be consistent. On the PUA side, PUC waivers were issued at some points in the PUA portal for some overpayments like the Gsi Double Pay, although back last summer we were telling people ignore that. PA doesn't have a waiver, and the department was agreeing with us. So, you know, this is again a shift in kind of policy for the department now in allowing these waivers. We have not seen a PUA waiver form yet. I have been asking the department about where that is and how people would find it. The form itself just asks people questions about why they mistakenly or incorrectly received unemployment, right? That's the kind of like equity argument. And then they ask for a lot of information about income and expenses. They really want people to show like they really can't afford to pay this money back. And they ask for documentation to go along with it. The way a waiver process works is the waiver is submitted back to the service center, and then the service center is supposed to issue a determination on the waiver. And if somebody disagrees, they have a right of appeal to a referee on the waiver. But because this is all happening kind of so suddenly and everything is already so backlogged, the referees have agreed to hear the waivers directly, even without a decision by the service center, if the waiver documentation is sent in along with the appeal. So if they file the appeal and attach the waiver documentation, then the referee will actually make the first decision on waiver, which again, if denied, would be appealable to the Board of Review. One thing is that these waivers, they don't have an online version somewhere. They don't have anything that people can download for this. It's just whether they've received it in the mail. And if they haven't, they're supposed to ask the service center to send them, which is all crazy and inefficient and never going to work with the mail and what's happening with the service centers. We're working to try to create an online form that people can use to submit the waiver information. And we're also going to be speaking with the department about ways to make this more accessible. But for now, know that some of your clients have this. You might see it on hearing notices. And if people ask you about waiver, should push them to apply for it for non-fraud overpayments. One thing we're unclear about is whether they're going to apply the waivers retroactively. I've asked the Federal Department of Labor for clarification on whether waivers should be retroactive. Because I'm a little bit worried the state's going to be like, well, when we collected it, there wasn't a waiver in place, so we don't have to give it back. Kind of like how they talk about when they collect fault overpayments and then it's switched to non-fault and they say, we don't have to pay that extra, 67% back because we collected it while it was a fault overpayment. So our reading of the law is that it is retroactive, and we're hoping that DOL will issue some clarifications on that, because otherwise people are really getting harmed by the fact that the department has dragged their feet on the waiver issue. And with that, that is it on overpayments. Let me see, I think we have, yeah.
If I could just interrupt here, I need to launch the poll for this training hour. Attorneys on the session, if you could please respond. I'll leave it up for 2 minutes. And Julia, please feel free to continue. Thanks.
Yeah, so Deborah, I see that you asked about, can you request her payment be refunded? The response that they have always given us is if it was collected while it was a fault overpayment, because they take the position that the overpayment is collectible as soon as the 15 days pass, even if it's under appeal, which is still something I think we want to figure out a way to address on a more systemic level. They say it was collected under good law, it was a fault overpayment, so we don't have to give it back. I always think it's helpful to ask because I like to have them put that in writing as much as possible in case we do want to do something about it. But that's often how they've handled it for at least the last 6 years. Okay, is it best to appeal first on a non-fraud, then potentially seek? So the first, with overpayments, the first goal is always to reverse the eligibility, right? The goal is to have them found eligible so that there is no overpayment, right? The second goal is to make sure it is non-fault or non-fraud instead of fault or fraud, right? So these are the kind of the levels of arguments you want to be making and focused on in the hearings. And then of course, if it is a non-fraud or non-fault overpayment, you should ask for the waiver and have the client submit the waiver. But you should always try to go after the eligibility issue first and foremost. Any other questions about that? We'll continue to provide updates as we have them on the waiver issues. And we also, this is kind of the wild, wild west of UC determination and referee decisions on waiver. We don't really know what they're going to be using to evaluate this, kind of what their standards are. Similar to the PUA system, like this is all new, it's new to them as well. So, this is really great opportunity for those of you on the plan listserv to share experiences of what has happened in these hearings, what sort of questions have been asked, and that sort of thing. Fault overpayments can be discharged in bankruptcy. That is the thing. Now, often we'll refer people to the Consumer Bankruptcy Project in Philadelphia to have their kind of entire debt structure looked at to see if bankruptcy makes sense in general. Very rare have we found that it makes sense for someone to go through bankruptcy just for unemployment debt, but it is dischargeable. Okay, so the last 10 minutes I want to spend talking a little bit about benefit modernization. So what is benefit modernization? As I keep talking about, our unemployment compensation system here in Pennsylvania is operated by a mainframe legacy system. That means it is a whole bunch of really huge computers in the basement in Harrisburg, kind of like old NASA computers. And that's what holds all of our data and runs all of the programming for the state. It's run on a language that is almost non-operable these days. People don't know how to change it, how to make program updates. So it's been really difficult for them to make changes quickly during this pandemic to the UC side. And so back in 2017, the state contracted with a vendor to update its system, to move it off of the mainframe, to make it more accessible. I have been serving on an advisory committee where I was appointed by the legislature to oversee this project for the last 3 years. It was originally supposed to be implemented in October of 2020, but we pushed for that to be delayed because we were very concerned about the implementation of a brand new system in the midst of this pandemic and the benefit lapses or errors it could cause when it goes live, because deploying new technology always comes with problems. It's never a clean or perfect process. So it got delayed, but it does look like it will probably end up happening sometime in the late spring, early summer of this year. So we will be providing constant updates about that, but you kind of already know what it looks like because our new modernized system is being created by Geographic Solutions Incorporated, the vendor for the PUA system. So what you've seen in the PUA system in terms of navigation, in terms of what information is available to claimants, that's what you see claimants will have access to at some point. It's actually much cleaner and better in the UC system because they've made lots of modifications to it over the last 3 years. And so there are lots of good things about modernization in terms of a lot of these issues people have with like manual holds and getting cut off incorrectly from benefits. Like that should all, when there's not a determination and things like that, that should all go away in the new system. However, I am very concerned and continue to raise my concerns about them going live with the system during the pandemic when we have 1 million people filing claims. There are going to be some questions about how login works, how people set up their logins, if they have a Keystone ID, which we're worried is going to confuse people. And we are just very worried that there are going to be problems in the rollout, especially because we don't have a lot of faith in Geographic Solutions Incorporated since they've done such a poor job in the PUA system and have been so slow to fix problems. So I have been very clear about my feelings with this with the department. I'm starting to be more clear in media when asked about it. So, we're waiting to see kind of what they're aware of some of these concerns, and we're waiting to see what they might do to address that before they go live with the project. But like I said, there is no date currently set for when they're going to go live with the project. I will keep you guys updated when we have updates, and as soon as we know anything, the department will be doing a lot of external communication about this when it comes to it, and we will too. One thing that is really frustrating about this is that we are going to be put in the same position that we are with PUA, and that we do not have our own access to the UC portal. We would have to log in as our clients with their username and password, which I have pointed out is horrible. We don't want to be doing that. They need to give us a point of access, especially because third-party administrators, like the employer representatives, they have a point of access. But of course, these systems that they're just kind of these pre-made systems that states are buying for these modernization projects never think, oh, workers might have advocates too. So they're not built with an access point for us. We've raised this several times. We've raised this to the legislature. There are some thoughts about workarounds that we're waiting to hear from the department, and they have said that post go live, it'll be a priority for them to get us a separate access point. But it is a real frustration for us that even though our clients may have access to a lot more good information after modernization, we don't necessarily have a good way to see that without doing what we're doing now in the PUA system and logging in as our clients, which we don't like doing. That's not what nobody wants to be doing that, because it raises all sorts of issues. So that's kind of where we are on benefit modernization. Like I said, as soon as there's information or updates, we will get back to you. We'll be sharing a lot of information. There are some guides already up on the unemployment website about the modernized system and how to use it. You'll note that the guides have a lot of explanation that go along with each question, which tells you that they made the questions too difficult to understand on their own. Unfortunately, we were not able to get them to make much in terms of language changes to the UC application, which is crazy because, as I think you all know personally now, no one understands half the questions on the UC application. And so that has just been really frustrating and something we've kind of also pushed with the legislature moving forward with the department. And so, like I said, I'll be back with updates on that as things change. I see somebody asked, are waiver forms available anywhere if they have not been mailed out? I don't think so. There is not like just a blank waiver form anywhere on the website. We have asked them for that. What they've said is you have to contact the service center for them to mail you one. How someone is supposed to do that is beyond me. So we're taking significant issue with how this is being approached, and are working to try to get them to make this more accessible, because it really just feels like they're hiding the ball with people, which is really harmful to lots of clients, especially for PUC, because the PUC overpayments are where the real money is coming into play, because an extra $600 a week that you're considered overpaid for adds up very quickly. So any questions on all of that? I know that I am currently standing between you and a lunch break, so it's possible that we don't, but this is your time. So Kevin, the problem with the client's blank waiver form is that, like, it has their name on it, and it has a specific service center, which is why we're trying to make an online version. But you can't, but like, if you want to just try to like white out or redact the name and have someone enter in their own name, I mean, like, I say we should be as scrappy as possible. So if there's ways that people can do that, if they have access to it, be scrappy, try to get these waiver forms in any way you can, because it's going to help our clients. But they do have people's name and address and everything on them when they're mailed out. Yeah, so that's, Eileen, that's what we're doing. We're trying to create, Eileen asked, can somebody create a template? So that's what we're doing. We're trying to create, in essence, a fillable online form that will kind of spit out a waiver for folks. So I don't know who asked about the claimant advocate resource account. That resource account is for legal aid in the state. So if you are at a legal aid organization, in the plan network, you should speak with one of your coworkers to get access to that email address. If you're not with legal aid in the state, then if you need to contact the department about a client's claim, or they need to contact the department, they need to go through their state rep or state senator to try to get that access point. But talk to your colleagues to see if you're at an organization that has access to that information. Okay, and with that, we'll go ahead and break for lunch. A reminder, as Kelly said earlier, you don't have to sign off. Just put yourself on mute, take your video off, walk away from your computer, please stand up. Please don't sit for the next hour. And then once we come back at 1 o'clock, you can, put your video back on mute, we'll come back, but there's no need to sign out of the system, to sign out of the Zoom right now for the lunch break. So thanks everyone. And I'm sure that we'll all be communicating about unemployment for the foreseeable future. So this is not the last you will hear from me or from my staff at PLA.